Good afternoon. Chair calls to order the special call meeting for the Greenwood LaFleur Consolidated School District Board of Trustees. May we bow here for a moment of silent prayer. Amen. Chair will entertain a motion to approve the agenda as presented. It's been moved and properly second. All in favor? Aye. Any opposed? Ayes have it. Motion carries. At this time, we will have the public hearing as requested by Mr. Johnson Waldington, who is being represented by Attorney Bailey. Just a few housekeeping items. Attorney Bailey and board, if at all possible, we do ask, if it's the will of the board, that we allow up to an hour so that you can make your presentation, if that is the will of the board and if that's okay with the board. Any feedback, colleagues?
That's good.
So are you saying you just give them 1 hour?
Yes, ma'am. It's the will of the board. Attorney Palmer, do we need to put that into a motion so they can be documented in the minutes? Chair will entertain a motion to permit Attorney Bailey up to an hour to make her presentation regarding the public hearing.
Second.
It's been moved and properly second. All in favor?
I want to hear what the attorney said.
Yep, you have a motion on the floor, Ms. Abraham. All in favor? Aye. Any opposed? Any opposed? Please let the record reflect the 2 nays. Ayes have it. Motion carried. Go ahead, Attorney Bailey. You got something to say?
Yes, I did want to say that.
Yes.
I wanted to interject.
Turn it on. Turn it on. We can't hear.
Can you hear me now?
Maybe it's something with Ms. Watson behind you.
Okay, thank you. I did want to interject that I do not believe that is sufficient time to present defenses and our positions in response to those 5 bases that were offered, and we would request additional time.
Mr. Colleagues, what is the will of the board?
I would agree to allow them, the time that is needed for her to present whatever evidence they may have. I would agree to allow them to have ample time to present all evidence that they have. I don't think we can put a time on it.
Is that a motion, Ms. Lewis?
Yes.
Second.
It has been moved and properly second to allow whatever amount of time that is necessary so that Attorney Bailey can make the case on behalf of Mr. Johnson Waldington. All in favor, vote by the sign of aye.
Aye.
Any opposed? Aye. Ayes have it. Motion carries. Also, Attorney Bailey, we do ask that we stick to the points that were provided to you by Attorney Palmer, if at all possible. We do ask that everybody speak into the mic so that those persons joining us via video are able to hear. Having said such, Attorney Bailey, the floor is yours.
Thank you. I want to start by saying thank you to the board members. I want to start by saying thank you. All right, third time's a charm. I want to start by saying thank you to the board members and to the public for being here tonight. My name is Shanae Bailey. I'm an attorney based out of Columbus, Mississippi, and I am here. I have been retained by MAE, the Mississippi Association of Educators, to present this matter on behalf of Mr. James Johnson Waldington and respond to the bases that were offered in support of his dismissal. I will just have some brief opening statements and then I will call my witnesses. Basically, I have previously provided electronically to all of the board members, hopefully everyone received them, the documentation that we will be relying on, and as well put 2 documents at each person's desk. Those documents were provided at a later time, and we may reflect on those documents as well tonight. We are having this hearing before the board. There was a request made by myself on behalf of Mr. Waldington to conduct this hearing before an impartial hearing officer, and it was relayed to me that that request was denied. So we are here tonight. And I believe that once we complete our presentation, it will be clear, crystal clear, to everyone under the sound of my voice that these bases are unfounded, they cannot be substantiated, and therefore we're requesting that Mr. Waldington be restored to his position as superintendent. Just as an initial thought to reflect on the frailty of these bases, I did bring, just for the public, and I do apologize, I forgot my easel, but I did bring for the public a printout or a blow-up exhibit that will showcase what these bases are. And we're just gonna knock these off one by one with our testimony and our documents tonight, and we will show you that they're unfounded. If you've read or seen anything in the newspaper, they've already touched on these subpar results from the 3rd grade state testing. We all know that those numbers went up, and they went up significantly, especially in light of the fact that these children, for the first time in 3 years, were back in the building in a traditional learning setting. That is phenomenal growth, given those circumstances. And then, of course, that was because of COVID. And we're also going to show you some proof tonight and give you some testimony tonight that there were no goals given to Mr. Waldington. And it is the responsibility of this board to provide him with goals. So when he had no goals, what did he do? He gave himself goals to hold himself accountable. He presented this board with SMART goals, which were provided, I think, in his superintendent report and adopted. And those SMART goals only called for a 5% increase, which he almost doubled. Looking at fiscal mismanagement, and we're going to take all of these, but I'm just pointing out some of the hot topics right now. Fiscal mismanagement. not proactively tracking the district's fund balance, and consequently borrowing 16th section land funds to cover payroll, December 2022. Now, this budget was adopted July the 5th. It's in your documents, and you all know that. Mr. Waddington started work here July 1. He had absolutely no input in the budget. And this budget, when it was adopted, had a significant shortfall. That shortfall that this board adopted in its budget is what led to Mr. Waddington having to take the steps that he took. And those steps were appropriate. And we believe that they were appropriate because you board members voted in favor of the transfer of the 16th section funds to cover payroll. That way, not a single employee of this district missed a check. Those are just some of the highlights. At this point, we will go ahead and call our first witness, if there's no objection to that, and we will call Samantha Milton. Where would you like for her to be seated? Ms. Milton, would you come forward? Will you be swearing the witnesses?
I do.
Please state your name for the record.
My name is Samantha Jackson Milton.
Ms. Milton, do you have a history with this board?
Yes, ma'am.
Did you serve on this board previously?
Yes, ma'am.
Could you provide the dates?
Consolidation started for Greenwood LaFleur Consolidated School District in 2019
And you served on this board from 2019 until when?
to December 2022.
Okay. And prior to that, were you on a different board that carried over? How
Yes.
did that work?
Well, actually, I served for Greenwood Public School District, and then I ran for my office for Greenwood LaFleur Consolidated School District.
Okay. And so if you were on the board up through December 2022, that means that you were on the board when Mr. Waddington was hired.
Yes, ma'am.
Okay. And you were a part of that hiring process. Can you explain a little bit about what this board did to get its candidates?
So we were a part of an association for board members, Mississippi Association, and for board members, MSBA. And we hired them for their services to vet a superintendent. So superintendents put in applications, and then they went through the applications and vetted and gave them to us. And then the board came together and we got the top 5 or the top 3, and we went from there.
Okay. And of course, Mr. Waddington was one of those top candidates.
Yes, ma'am.
And was he ultimately interviewed?
Yes, ma'am.
Okay. And during that interview process, did you have the opportunity to ask him questions and look at his education, experience, things of that nature?
Yes, ma'am.
Okay. What was it about him, if anything, that led you, well, let me ask you this question first. Did you vote in favor of hiring Mr. Waddington?
I did.
What was it about Mr. Waddington that led you to vote in that manner?
Looking at his tenure, looking at how MDE had used him for different services as conservator, and his different placements and assignments by MDE, looking at his resume, and just the success rate that he had as a superintendent.
Okay. And at looking at the contract which is attached, to the documents that were provided to the board, on page 26, you signed that contract on February the 18th, 2022. Does that sound correct?
Yes, ma'am.
Okay. And so, but the contract's effective date was not until July 1 of 2022. Is that correct?
Correct.
And so between February the 18th, 2022 and July 1, the effective date, did you have the opportunity to speak with Mr. Waldington regarding various school matters?
Yes, ma'am.
And what were some of those matters?
Just allowing him time to do the things, because the board at that time was very concerned about the success of the students and the data. And so we just want to give him enough time to be able to turn the data around from what it had been.
And on occasion, did you call him on the telephone?
Yes.
Did one such occasion arise on March the 23rd, 2022?
You have to show me so
Okay.
that I can know what you're talking about.
I'm just gonna, nobody should talk about this document.
Yes, ma'am.
Okay. And so that document indicates that there are a number of people in executive session.
Correct.
Okay. And amongst those people in executive session, it lists James Waldington. Is that correct?
Correct.
All right. And the way that, how was he in executive session? How was he present?
Via telephone.
Did you personally call him?
Yes, ma'am.
And was he on speakerphone?
He was.
And during that call, did you at any point introduce the people that were present in the room?
Yes, ma'am.
Okay. And did you say anything else?
Introduced the board, and we also had a outside legal counsel that was there, and I introduced him as well.
And did you at any time indicate to Mr. Waldington that you were in executive session?
Yes, ma'am.
Okay. Do you know whether Mr. Waldington heard you?
I can testify that I said it, but on this particular date, it was kind of contentious because we had done a feasibility study, and we were chitter-chattering because of opinions of each board member, so it was a lot going on. And so I can recall just having to say, quiet down, because we debated a lot. And so a lot of sidebar conversations. Then we also had, so there's if you look over there under the flag, there's a conference call, like telephone. So we had an outside legal attorney on that, and then I had Mr. Waldington on my cell phone. So it was a lot of confusion, a lot of talking, and like mumbling and chattering among the board members. I can testify that I said that, but I cannot testify that I know that he heard it, because I didn't ask him to recall what I said.
Okay. Would there have been anything improper about Mr. Waldington being on the phone during executive session?
Not to my knowledge.
Not if you invited him.
Correct.
Okay. And would there be, I'll strike that. Yes, ma'am. Now, in terms of the budget, let's move to that, and that is going to be, and what you just gave testimony about is going to be the violation of the code of ethics, the second bullet. Let's talk about the fiscal management. Now, the documents that we have show that this budget was adopted on July the 5th, 2022. Do you recall that, or would you like to see that?
I would like to see it.
Sure.
Yes, ma'am.
At the time that the budget was adopted, was there a shortfall?
Yes, ma'am.
Okay. Can you report for the record what that amount was?
So according to this budget, it was in the millions.
Okay. And this budget was adopted a mere 4 days after Mr. Waldington's effective date of hire.
Correct.
Now, at some point during the latter part of the fall semester, the latter part of the fall of 2022, Mr. Waldington approached the board about the shortfall and provided options. Is that correct?
Yes.
The options were to borrow from 16th section funds or get a short-term loan.
Yes.
You recall that?
I do.
Okay. And which option did the board employ?
16 section land money.
Okay. And do you recall who voted in favor of that motion?
I would like to see the record, but if my memory serves correct, I think I was the only board member who voted against it. I believe everybody else voted for it. If I could see the minutes, I could tell you.
Bear with me just 1 minute, I'll provide that to you.
According to the minutes, it says that Mrs. Milton, Mrs. Lewis, Mrs. Abraham, Dr. Bailey, and Dr. Moore all voted yay.
I think you may be looking at a different page.
Oh yeah, this is approving the agenda, I'm sorry. Okay, I don't see on here with the 16 section land. Okay. All right. Voting yay, I'm sorry, Mrs. Lewis, Dr. Moore, Ms. Abraham, and Dr. Bailey, and voting nay, Mrs. Milton, but the motion was passed.
And what again was the date of that meeting?
The date of this meeting was December 12th, 2022, 12 o'clock p.m.
Thank you. Had this transfer not been made, would the district been able to make its December payroll?
No, ma'am.
Now, jumping back again, I'm sorry, to the violation of the code of ethics, this testimony. session while Mr. Waldington was on speakerphone. This issue arose again in December during an employee's termination hearing. Do you recall that?
Yes, I do.
And again, for the protection of employees, we're not going to state anyone's name. We generically refer to the person as an employee, okay? As an employee. And during that, were you present during that termination hearing?
Yes.
And I understand that Mr. Waldington testified that he was not in executive session when he was on that call on your speakerphone. Is that correct?
That's correct.
Okay. And that is the basis of this supposed violation of the code of ethics. And again, you testified that you can't be certain that he knew that you were in executive session.
No, ma'am, I cannot be certain. I can be certain that I said it, but I cannot be certain that he heard it.
Now, throughout the course of the year from July 1, 2022 until the end of the year, it's December 31st, 2022, you had the opportunity to work hand in hand with Mr. Waldington.
Correct.
How would you describe him as the superintendent?
What impressed me about him as a superintendent is that he's data driven, and that's what we were looking for, to turn this district around, for student improvement. And he also came in as being a champion for children, and so that impressed me as well.
Are you aware of any of his successes or improvements throughout the year that you'd like to discuss with us, to share with the board?
With the third grade gate, showing that he showed improvement from the year before.
All right, that's all I have.
And I would also add that in board meetings that he would have around the walls showing us the progress that he was making, and we weren't used to that, seeing everything that he was doing to improve student achievement.
And what do you mean by everything he was doing?
As far as working with his principals, they would gather the data and he would have it on the wall to show us where they were.
And just one last question, going back to the fiscal management. Was the board provided with monthly updates and monthly financial statements regarding the budget?
So we did get that in meetings from the business manager, but I can say that when he first was hired, I begged the board we had gone to a MSBA conference, and one of the things that they showed us was a dashboard from Oxford or either South Panola, and I begged the board at that time to let's mirror what Oxford was doing, and that way that could hold the superintendent accountable, and on a monthly basis that we can see the stakeholders in the community, meaning the parents, the community leaders, that they could see what we were doing, because it could be on Facebook, it would be on our district website, but I didn't get one vote. And that way I would have known, and the board would have known, that we were holding him accountable, and he would know what it was that the board was looking for.
So in essence, the board refused to adopt those?
Yes, ma'am.
That's all I have.
I just have a couple of prompts. Ms. Milton, good evening.
Good evening.
How are you doing today?
I'm good, and you, Mr. Palmer?
Doing well, thank you for asking. Just a few questions to follow up with what Attorney Bailey asked you.
Can you hear me?
I hear you well.
I'm used to being in church and being able to project my voice. Ms. Milton, you testified regarding budget shortfalls. Do you have any personal knowledge from your experience as a previous board member as to what causes a budget shortfall within a district?
Well, I'm gonna say it like this: as a board member, finances are not my plus, so I always lean on the business manager to tell me from A to Z on what is going on, because that's not my forte.
Understood. In your experience as a board member, are you aware that from year to year, sometimes the legislature for the state of Mississippi does not fully fund education throughout the state?
Correct.
Would you have any personal knowledge as to whether or not that is one of the reasons for districts having budget shortfalls?
If I can recall correctly, Mr. Palmer, it was due to us losing money due to things that were not turned in on time. So we lost money.
But would it be fair to say that you cannot testify as to whether or not the legislature's appropriation to education in Mississippi being one of the root causes for this district's shortfall during the time that you're talking about?
Yes, I can attest to that, and it's because of things that were not turned in on time. They allowed us to understand that if we didn't meet deadlines, we lost money due to that.
Ms. Milton, why did you vote nay to borrowing from 16th section land in order to supplement the budget shortfall of the district during the time that you referred to?
Due to trainings at MSBA, they always taught us to stay away from 16th section land money because it'll get a board in trouble more than anything.
And my last question is, can you personally testify as to Mr. Waldington's relationship with the board of Greenwood LaFleur Consolidated School District after December 31st, 2022?
Say that again, Mr. Palmer.
All right. My question is, can you personally testify as to what type of relationship Mr. Waldington had with the board starting January 1st, 2023 and beyond?
No, sir. Only thing I can rely on is what I see in the newspaper. But I cannot testify as to how they relate to one another.
I have no further questions. Thank you.
Everybody could do the microphones a little bit more like that, that'd be great.
The next witness I will call will be Ms. Mary Abraham.
Point of clarity, Ms. Abraham, and it's certainly your right to sit as a witness. Based upon advisement from counsel, it may be a potential conflict for a board member to sit as a witness, and again, it's her right, and also deliberate when taking a vote if to uphold the termination or not. Just want to state that for the record.
And we've done our research on this matter, and as long as they are facts that she is testifying to that occurred in executive session, we are understand that it is appropriate. And there's going to be only one specific area that she will testify about regarding the reprimand or the attempt to reprimand.
Yes, ma'am. Ms. Abraham.
I do.
Please state your name for the record.
Mary Magdalene Abraham.
Ms. Abraham, you are a sitting member of this board, is that correct?
Correct.
And you were present January the 4th, 2023, in an executive session when the issue of Mr. Waldington's truthfulness arose regarding his presence on the March 2023 call on Ms. Milton's speakerphone.
I was.
Was there a motion made?
Point of clarity.
Point of clarity. What date in March did you refer to? I think you said 2020.
Let me clarify again, because it was a long question. The executive session was January the 4th of 2023, and it concerned Mr. Waldington's truthfulness during, as to whether he was in executive session on February the 23rd of 2022. Were you present?
I was. in January.
Speak closer.
I was.
Did this issue arise during the executive session?
It did.
What was the nature of the discussion?
Well, from my memory, the discussion was that Mr. Waldington had not told the truth during the February meeting, and it was an immediate wanting a reprimand for him from the board.
And just a point of clarity, was there a termination hearing in December when this issue of the executive session in February when it arose?
Yes.
And so, who was the board member who made the motion?
I don't have the minutes before me, but it was Dr. Bailey that I remember.
Okay. And who was the second, if you
I
recall?
don't remember. If I see the minutes, I can.
And unfortunately, I don't have the minutes. But do you recall the ultimate vote? Was it passed or did it not? Did it fail?
It failed because of the lack of evidence that I felt was not there. I voted obviously no.
That's all I have.
Attorney Palmer, if necessary.
Ms. Abraham, good evening.
Good evening.
Just one question. You were asked about the reason why that particular motion did not pass regarding a potential discipline of Mr. Waldington. Do you recall that question that was just asked?
I do recall.
Is it normal when a board votes that the outcome is based upon the number of board members or majority that votes for that measure? Would that be accurate?
That's correct.
And regarding this particular motion that was posed before the board, are you saying that a majority of the board regarding that particular vote voted not to discipline Mr. Waldington for whatever the allegations were at that time?
That is my memory, yes.
I have no further questions.
We will next call James Johnson Waldington.
I do.
Please state your name for the record?
James Johnson Waldington.
Mr. Waldington, these members are pretty familiar with you, but I would like for you to give them the benefit and the public the benefit of your educational background.
I have a master's level degree in educational leadership from Delta State University.
And share with us a little bit about your work experience.
I have 23 years in education. Of those 23 years, 19 has been in administration, 7 in as a secondary school principal, and 12 as superintendent of schools.
Tell us a little bit about the process in which you came to interview with Greenwood LaFleur Consolidated School District.
The Mississippi School Board Association made an announcement that there was that the Greenwood LaFleur Consolidated School District was looking for a superintendent. They were advertising for it. So I applied for that particular position, and I was notified from MSBA that I had made it to where I was able to receive an interview before the board of Greenwood LaFleur. And I, arrived for that interview. It was in February. I can remember it was very, very cold that day. And I had the interview with 4 of the board members that were there. And following that, I was notified, I don't know exactly the time period or sometime lapsed, that I was notified that I had been offered the position.
Okay. And which 4 board members were present for your interview?
Samantha Milton, Jackie Lewis, Mary Abraham, and Dr. Calandra Moore.
Did you understand that there was a split vote in hiring you, that it was not unanimous?
Yes.
Okay. Do you know which board members voted against you?
Yes, ma'am, I do.
Who were they?
Dr. Roshan Bailey and Dr. Calandra Moore.
At any point after you were hired, did any of the board members, did either of the board members who voted against you approach you and express to you what their reservations were regarding your employment or things that you needed to do in order to gain approval?
No.
So let's jump forward a little bit out of order here, but to June the 6th. The makeup from the time that you were hired in February of 2022 until June the 6th of 2023 changed. Is that correct?
Yes, it did.
Okay. And so who was out and who was in?
Ms. Samantha Milton was out and Mr. Henry Fant was in.
And that occurred, that was effective as of January of 2023?
January 1st.
Now, on that evening of January the 6th, do you recall the interchange in executive session when you were, when the motion was made for your termination or dismissal?
Yes, I remember.
Okay. Can you relay that to us today?
Yes. The last thing in, the last item that was taken up in executive session was performance of the superintendent. Dr. Roshan Bailey began to read, some reasons that he felt like that my job was the job that I was doing was insufficient, subpar test scores, violation of code of ethics, not contacting MDE about the board meetings, and it was a couple of more that was on there. And, and I'm listening, to these things, and then I heard the one about the violation of code of ethics, about, the being in the executive session and saying that I was not during a termination hearing. And I'm thinking in terms of, you know, we've dealt with that. And with that being said, once he got done, he said, for these reasons, I'm making a recommendation for termination of the superintendent. And he asked for a second. There was silence in the executive session. Henry Fant began to talk, and you know, he was talking about, you know, the district not going in the right direction. I asked, I'm like, you know, what does that mean? You know, and I began to talk about the test scores that we already had from third grade gate. Talked about the test scores as far as pre-K is concerned, that, you know, that we went up double digits percentage-wise in the students scoring at the level that they should based on state standards. Kindergarten, those are only 3 that we had. I talked about the Excel Academy that we had in place, you know, to help with those things that we were trying to do. I talked about those kind of things, and, you know, because this totally caught me off guard, you know, I was trying to explain, you know, or plead my case based on things that just, you know, came up. And, you know, Mr. Fant said that, that I must be, something to the effect of me must be, you know, understanding what they're saying because I was getting emotional. And I'm like, you know, this is something that is just brought up on me. You would get emotional as well, you know, because I, you know, had no idea, you know, that this was going to happen. But that's the way that it happened. Then the motion was put forth again, and by Dr. Roshan Bailey, and it was seconded by Mr. Fant and Ms. Dr. Moore voted yay, and Ms. Abraham and Ms. Lewis, they voted nay, and that was that.
And then on the following day, you received a letter from Attorney Carlos Moore, is that correct?
Yes.
Palmer, Attorney Palmer.
My apologies. Is this a copy of the letter that you received?
Yes, the front page.
And on the front page, let's just go ahead and read this into the record. You have a copy there, is that correct?
Yes.
Okay. To start with, dear Mr. Waldington.
Dear Mr. Waldington, as you're aware, the GLCSD Board of Trustees conducted a regular meeting on June 6, 2023 at 5 p.m. at the GLCSD Central Office. During the meeting, GLCSD Board, by majority, voted to dismiss you as Superintendent of Schools for the Greenwood-LaFleur Consolidated School District. Pursuant to the provisions of the Mississippi Code annotated 37959, you are hereby notified that you were being dismissed for the following reasons concerning incompetence and neglect of duty. Subpar results, data from third grade state testing for the 22-23 school year, violation of educator code of ethics as based on testimony you provided during hearing in December 2022, fiscal mismanagement, not proactively tracking the district fund balance and consequently borrowing 16th section land funds to cover payroll, failure to notify MDE of special call meeting for May 31st, 2023 pursuant to MDE prior directive, violation of due process of an GLCSD employee. Because of these reasons, the GLCSD Board of Trustees has dismissed you as GLCSD Superintendent. You are further relieved of all duties that office as of the date of dismissal. Accordingly, please immediately remove all of your personal items from your office. All personal items should be removed by 4 p.m. today.
So it goes without saying that if you were immediately relieved of your duties, you were not offered a pre-termination hearing. Is that correct?
That's correct.
And it was your option to elect to appeal the action of the board to the board.
Could you repeat that?
You had the option to request within 5 days to appeal the board's action.
Yes,
And you requested a public hearing.
yes.
And you also requested through my office for this hearing to be before a hearing officer, an impartial hearing officer, and that request was denied.
Yes.
All right. So let's start. We're gonna take these bases one by one. And the first basis that we're gonna go into in some detail here is the one regarding the subpart third grade 2022-2023 test scores. Were you given specific goals when you were hired as superintendent?
No.
Were you ever given goals after the date of hire throughout the 11 months that you served as superintendent? Was there a time when you were subsequently given goals?
No.
What did you do, if anything, to hold yourself accountable?
I thought that it was very important that that we had goals for ourselves. We have to have goals. We have to have a target that we are trying to achieve, because if we're not growing, we're not doing the job that we need to be doing. So I created some SMART goals for the district, which are measurable goals, and using the data from 2021, created some goals for each of the areas that we had when it comes down to the academics, not only academics, but infrastructure, when it came down to chronic absenteeism, parent-student engagement, parent-community engagement. All of those are leading indicators of an effective school district. So with that being said, that those were goals that I came up with as the district is concerned, because I didn't have any of my that were given to me by the board. So those were created. Those were given to the board at work session, and those were approved by the board at a following board meeting.
Now, those goals are in the documents that were provided on pages 7 through 17. Is that correct?
Yes.
Now, let's go specifically to the third grade state test scores. Those are in our packet on pages 4 and 6. What were the numbers for 2022?
For 2021-22, the initial passing percentage for the Greenwood LaFleur Consolidated School District, as issued by MDE, was 40%.
And let's turn to page 4 so we can have the exact percentages that were reported by MDE, if you don't mind.
But
Go ahead, what was the overall passing percentage?
for the Greenwood LaFleur Consolidated School District, it was 40.4%.
And then provide the percentages for each individual school.
Bankston Elementary School had a 62.3% passing. Davis Elementary School had a 47.9% passing. East Elementary School had a 39.7% passing. LeFlore County Elementary School had a 43.8% passing, and Threadgill Elementary School had a 19.7% passing.
All right. Now flip over to page 6 and provide those numbers for 2023.
For the 2023 school term, Greenwood LaFleur Consolidated School District had a 49.4% passing. Bankston Elementary School had a 55.3% passing. Davis Elementary School had a 54.3% passing. East Elementary School had a 49.5% passing. LeFlore County Elementary School had a 45.9% passing, and Threadgill Elementary School had a 43% passing.
And so that was an overall increase of what percentage?
For Greenwood LaFleur, for the district, we had a 9% increase over the year before.
And in the SMART goals, what goal did you set for yourself for this particular test?
5%.
So you almost doubled the goal that you gave yourself.
Yes.
And it appears that all but one of the schools, their percentage rate increased as well.
Yes. All but one. And Threadgill Elementary School, which was in the previous year before I got here, had the lowest initial passing on third grade gate in the state of Mississippi as far as schools are concerned, at 19.7%. But this year, Threadgill Elementary School had a 43% passing, which is an incredible increase over the year before. And, it was based on holding, from my office, holding principals accountable, giving them what they need to be successful, and assisting in any manner that was necessary to help the children to be as successful as they could be.
In your opinion, is there any basis for a statement such as the one that was in your termination letter saying that these scores are subpar?
No.
Is there anything significant about these children who took the test and the effect of COVID?
Right. I'm 100% champion for children, and I'm not ever going to put a blame on a child for what it is that it is our duty as the adults in the district to give them the best education that we can. But these students, these particular third grade students, when COVID hit and schools were shut down in the state of Mississippi in March of 2020, they were kindergarten. And they did not get back into a traditional school setting until this year, meaning that, they missed almost 9 weeks in their kindergarten year. They missed their first grade being virtual and their second grade being virtual. And those are very, very important years as far as skill building when you're talking about the children when it comes down to the third grade ELA exam. So with that being said, they were missing most of that face-to-face instruction from their first and second grade teachers that would have definitely assisted them in being more successful on that test.
And did you do other things in order to assist with the increase of the scores?
Yes. We, in the school district, we track data, okay? Meaning that our first 9 weeks benchmark assessments, second 9 weeks benchmark assessment, third 9 weeks, we track the data and we make adjustments as we need to for those students. Also, we introduced a district-wide intervention, online intervention, which we used, which was iReady, to be able to help with the skill building as well. And those students had to complete 90 minutes a week on ELA for that particular situation. We were tracking that data as well. Also, after the first 9 weeks exam, we saw that our students, as far as third grade was concerned, were not they were not growing at the level that we would hope that they would be. So we, the curriculum team, spoke with the teachers and found out it's not about the standard, it's about the skill. The students, were missing those skills. So with that being said, myself and the curriculum team, we came up with a plan of action for an after-school program for skill building for those students. And we knew that we needed to have the experts in the district to be able to teach those skills. So we went and spoke with our kindergarten through second grade teachers to see would they be willing to do that, and they were. So we brought that proposal to the board for approval. I explained to them why we were doing what we were doing for the third grade students, and we had that after school program all the way up until we began to test as far as our state test is concerned.
And is it your opinion that it's a combination of these systems that you spearheaded and helped to put in place that led to the 9% increase in these students' test scores?
Yes.
Did you have anything additional that you wanted to add regarding the third grade test scores?
No more than, that, we as a school district, the teachers that were teaching the students, we made sure that we kept up with the attendance as far as the students were concerned. If a student was missing more days, we would get in contact with the parent. We did all that, that we knew as for looking at the leading indicators for success to make sure that those students had what it is that they needed for success. And I am very, very proud of the, of the growth that we had. I'm proud of the teachers, the work that they did, because it was very, very hard work to teach standing to a student that don't have the skills to be able to understand what the question is asking. But they did a really good job with that, and I appreciate their work. But it was it was remarkable work.
Thank you. We'll move now to the second bullet, which is the alleged violation of the Educator Code of Ethics, as based upon testimony you provided during an employee hearing in December of 2022. Now, at the time, you heard Ms. Milton testify earlier that you all were in contact during the interim time after you were hired, but prior to the effective date of your contract. Was that accurate?
Yes.
For what reasons were you in contact with Ms. Milton?
We discussed, I wanted, as the superintendent, I wanted to be able to review some documents, our curriculum plan, our professional development plan, those things, our plan as far as our federal programs is concerned, for the upcoming year. If that hadn't been done, we'd like to have seen what we were doing the previous years. I wanted to be able to have a running start when I come in July. As far as information is concerned, I wanted to be able to meet with employees that were coming, that signed contracts and were coming back, talk to them about their position, let them explain to me what they did, what could I do as the superintendent to assist them, to be successful, talk to them about, what my vision is for the district and the expectations that I have, and that, just those kind of things. I would speak to her about, assisting me with getting in contact with the right people to do that.
did the board, offer you a 10-day consulting contract in order to, help you accomplish those things?
Yes,
Were those contacts with Ms. Milton, by phone, in person, via
By-
Zoom?
by phone.
In terms of this, bullet 2, this violation of the Educator Code of Ethics, what is your understanding of what you're being accused of?
I think that I'm being accused of knowingly and willingly lying about being in executive session with the Greenwood LaFleur Consolidated School District Board on the phone. And you know, and with that being said, you know, that is the farthest from the truth. The truth, when the question was asked of me during the hearing, you know, at that time, all I could give was the truth of that I knew. And I was like, no, you know, because I didn't know that that was the case. And with that being said, you know, that's the reason why I gave the answer that I gave. And, you know, not trying to hide anything, not to say that it would have been unlawful for me to be there, or unethical for me to be there, or anything like that. I said it, you know, at the time because that was my truth.
Would there be any reason for you to misrepresent during that hearing whether you were in executive session or not?
None. No.
And I think you hit on this a bit, but would it have been out of order for you to be in executive session?
No.
Was it a violation of any rules or procedures that you're aware of?
No.
Did you know, at the time that you gave that testimony in December, that the board was in executive session when you were on Ms. Milton's speakerphone?
No.
If Ms. Milton said it, and she testified here today that she did say it, did you hear it?
No.
Let's turn to page 48 of the documents, and that's the actual code of ethics that you're accused of violating. And on page 48, you'll see the standard 2, that is trustworthiness.
Yes.
And although it doesn't specify the bases, they don't specify which ethical prong you've allegedly violated. I guess we have to assume that it's standard 2 dealing with truthfulness. Do you mind reading that first paragraph there?
An educator should exemplify honesty and integrity in the course of professional practice and does not knowingly engage in deceptive practices regarding official policies of the school district or educational institution.
And that word knowingly, does that imply that there is an element of intent to this particular trustworthiness standard?
Yes.
Did you knowingly engage in any deceptive practices?
No.
Was it your intent to engage in any deceptive practices?
No.
Now, Ms. Abraham testified very briefly that this issue came up yet again in January of 2023 at the very first board meeting. I believe it was January the 4th. Do you recall that?
Yes.
Okay. And during that executive session, just as best you can recollect, provide some information or the details of a discussion that occurred.
During the executive session, again, we had several items that we talked about, but at the end, well, I guess towards the end, I was actually stepped out of executive session. So I went into my office for, you know, a time, and then I came back, and there Dr. Bailey stated that, you know, that I had, you know, basically told an untruth, a lie, at the hearing concerning being in executive session, and that was a violation of the code of ethics. And and again, just as I just stated now, I stated at that time that that I did not, all I could do is tell you my truth at that time. I did not know that I was in executive session. So with that being said, he made a recommendation for written reprimand for me. Dr. Bailey made a recommendation for written reprimand for me for the violation of the code of ethics, and it was second by Mr. Fant, and it was called for a vote, and it did not pass because it was a 3-2 vote, against the reprimand.
Okay. And do you recall who voted against the reprimand?
Yes. Dr. Calandra Moore, Mary Abraham, and Jackie Lewis voted against the reprimand.
So this very same board refused to reprimand you for this alleged educator code of ethics.
Yes.
And now this same issue, the allegation is now that as a basis for your termination.
Yes.
Do you have anything else you want to add under the violation of the educator code of ethics?
No.
All right, we'll move now to the third bullet, which is fiscal mismanagement. Now, if you'll look in the documents provided on page 36, there is a copy of the combined budget report for Greenville-LaFleur called Consolidated School District dated July the 5th, 2022. Do you have that?
Yes.
And was that the date that it was effective?
Yes.
July the 5th, 2022. And that was mere 4 days after you were hired.
Yes.
Does this budget, well, let me ask you this. Did you have any input on any of the line items in the budget?
No.
Were you asked where any of the monies or where any of the focus should be placed with respect to this budget?
No.
So this, in essence, was inherited.
Yes.
And the prior board with Ms. Milton and without Mr. Fant, they were the ones who adopted this budget.
Yes.
Now, does this budget indicate, as indicated, does it show a deficiency or a shortfall?
Yes.
Just kind of give us and the public the benefit of some of the numbers in this budget.
The excess deficiency over of revenues over expenditures, the total amount that is listed here is $697,509.96.
Now, in addition to this budget deficiency, were there other concerns regarding the business office when you arrived as superintendent of the school district?
Yes. Once I was able to, from July until August, I was able to get a better understanding of the different areas that we had. And when we were talking about our budget, I was I asked the business manager for a copy of the audit for the district from the previous year, and she stated that the audit had not been completed. I said, well, let me have the audit for fiscal year 21. And she stated that that audit had not been done as well. So, I, in a meeting with her, I kind of said out loud, how can we do a budget? How can we construct a budget without having the audit done? And it was brought to my attention that not only that the audits were not done, but the bank reconciliations for that school term, 21-22, had not been completed in the district. So with that being said, knowing that you have not had all of your bank reconciliations completed, you really don't know what your fund balance is. You don't know because you have not reconciled all of your outgoing and incoming. So with that being said, the business manager being new, she's working to fix things. I brought to the board a recommendation to have an outside consultant to complete the bank reconciliations for 21-22.
And did the board approve that recommendation?
Yes.
And I believe that will be found on page 55 of your documents, where the board approved MSBA as a financial consultant at a rate of pay of $175 per hour to complete pertinent tasks in the business office.
Yes.
Is that correct?
Yes.
Did the board receive any monthly reports regarding its finances?
Yes.
Would those be in the manner of exactly what's in that budget and what's not in that budget?
Yes, the expenditures for the month or maybe the previous month that allows for the tracking of the budget, yes.
And at some point during that fall semester, did you, I guess the entire fall semester, but at some point, did you approach the board with several options on how to prevent a shortfall and cover payroll for the month of December?
Yes.
Expound on that if you will.
It was brought to, through my, looking over the financials and speaking with the business manager. It was brought to my attention by her that, that we were going to have a shortfall as far as payroll is concerned. So I talked to her about, the fact of that in the past, in my past experiences, there have been short-term loans that schools, districts would get, but they could also, quote unquote, borrow money from themselves. I mean, moving money from one fund line to another to be able to cover that. And I talked to her about as far as 16th section is concerned, and I asked her, I stated, I said, I want you to make sure that this is something that we could do. And she brought me the policy as far as the transfer of funds are concerned. And with that being said, at the next board meeting, it may have been a board meeting or it may have been a board work session, in executive session, the business manager and I explained to the board the shortfall and that we would, that our recommendation is either the short-term loan or, as far as 16th section is concerned. And if there is 16th section, that money would be placed back into 16th section once we begin to get our ad valorem taxes in January through June.
And this policy that you just referred to, is it policy DCI that's found on page 58 of our documents?
Yes.
Okay. And that policy gives you the authority to do what?
To make the recommendation to the board as far as a transfer is concerned. It's transferred within budget functions. It states if it should appear to the superintendent of schools or the school board of the school district that some function of the budget as filed in excess of requirement of that function, and the entire amount budgeted for the such function will not be needed for expenditures. Therefore, during the fiscal year, the school board of the school district, with assistance from the superintendent, may transfer resources to and from functions within the budget when and where needed. However, no such transfer shall be made from fund to fund or from function to function, which will result in expenditure of money for purposes different from that for which the money is appropriated, allotted, collected, or otherwise made available for purposes which is authorized by law. No revision of the budget under provisions hereof shall be made which will permit a fund expenditure in excess of the resources available for such purposes.
And this policy, again, allowed the board to transfer money from fund to fund, the 16th section fund, to the general fund in order to meet payroll. And if you'll look at the documents, page 51, I believe that encompasses the vote that Ms. Milton testified about earlier, where it actually passed.
Yes.
And so it looks like Ms. Lewis motioned, Dr. Moore seconded to borrow the $784,307.13 from 16th section interest to be paid back. And everyone voted yay except for Mrs. Milton, and it passed. Is that correct?
Yes.
Would there have been any point in time that you're aware of where the board would not have known that there was a shortfall?
No.
Because it was there present on the board budget as adopted initially.
Yes.
And those amounts were reported to the board monthly.
Yes.
Is it your opinion that you took the appropriate action in terms of the recommendations that you made to prevent the shortfall?
Yes. Was
there anything different that you should have or could have done in terms of this budgeting issue?
No.
And this shortfall, this was something that you solely inherited. You did not input in this budget at all.
No.
Do you have anything additional regarding the topic of fiscal mismanagement?
No, I don't.
All right, so we'll move to the next bullet item, which is failure to notify MDE of special call meeting for May 31st, 2023 pursuant to MDE prior directive. And so as worded, did this happen? Did you fail to notify them of the meeting?
It was, no, it was not my responsibility, be it from my job description, nor from a voted mandate from the board for me to notify MDE of the meetings that we had. So with that.
Let me interrupt you. But as my question was, as it is written, it says failure to notify MDE of special call meeting. Was MDE notified of the special call meeting?
Yes.
So MDE knew that there was a special call meeting for May 31st, 2023 pursuant to its directive.
Yes.
Is there any doubt in your mind that they knew about it?
No doubt.
Okay. What MDE didn't know was that the meeting was not able to be conducted because there wasn't a quorum. Is that correct?
Yes.
But as this bullet is written, they knew about the meeting.
Yes.
Okay. Even though you're saying that it was not your responsibility to inform them, they did know.
Yes,
So as drafted, that particular bullet, in favor of your dismissal is absolutely inaccurate.
Right.
But even if somehow they can prove that if this is actually talking about the failure to notify MDE of the cancellation of the meeting due to lack of quorum, that was also not your responsibility, was it?
no,
Who was responsible for these notifications?
the board clerk.
And this comes from a letter from Dr. Joanne Malone. It's on pages 43 through 44 of our documents. And this letter from Dr. Malone is dated April the 12th, 2023. It's addressed to both Dr. Bailey and yourself. Is that correct?
Yes,
And the letter states that MDE's Office of Accreditation continues to receive complaints regarding allegations of violations of Accreditation Process Standards 1, 1.1, and 1.2 as published in the current edition of the Mississippi Public Schools Accountability Standards, despite the warnings issued to the Greenwood-LaFleur Consolidated School District Board on April the 7th, 2022 and August the 4th of 2022. Therefore, MDE is requesting that the Greenwood-LaFleur Consolidated School Board notify the Office of Accreditation of all board meetings regularly scheduled and special called and work sessions until further notice, and grant teleconference access to all board meetings, including executive sessions, so that MDE auditors can continue to monitor the actions of the board to determine compliance with those process standards. Did I read that correctly?
yes,
Okay. And then further on in the letter, Dr. Joanne Malone, who's the author of the letter, also asked for a plethora of documents to be provided to them, including agendas and draft minutes and organizational charts and those types of things. Is that correct?
yes.
Who was the person that put together all of that information?
The board clerk.
Okay. Did you at some point offer to deliver those documents down to Dr. Malone's office, the Office of Accreditation?
Yes,
And what was, and I guess this was, the offer was made to Dr. Bailey?
right. It was via email, actually, to all of the board members, was included in the email.
Okay. And what was the response that you received?
Dr. Bailey responded stating that the district school board attorney would be delivering that information to MDE, and that he would receive written documentation that it was delivered by the time specified in the letter.
And again, these Mississippi Public School Accountability Standards, they're on page 46 of the document. These have to do with a school board's responsibilities and them not interfering or meddling in day-to-day operations.
Yes,
Okay. And does that have anything to do with your job and your duties as superintendent?
no,
And you're familiar with Mississippi Code 37-9-14, which sets forth statutorily what your duties are. Is
yes,
that correct?
yes,
Is there any place in there where it says you have to notify MDE when the board is exceeding its authority?
no,
Or accused of exceeding its authority? I'm sorry. Was the board, or did the board ever direct you to perform any tasks
no,
in connection with providing the notifications and documents that are listed in that April 12, 2023 letter?
no,
Okay. And other than your offer, which was refused, did you take any action to provide notification or those documents?
No.
Now, there are a couple of letters from my firm in this packet that are on pages 39 through 42. I was directed by by Attorney Palmer to submit the document request on your behalf to the interim superintendent, Mr. Brooks. Some of those requests were for any emails, any electronic documents transmitting the documents requested or the notifications to Dr. Malone's office. Did we ever receive those?
No, ma'am.
And you reviewed all of the documents that the district produced, is that correct?
Yes.
Okay. So we were not asking for the documents themselves that were transmitted, were we?
No.
We were asking for the actual transmittals to determine who transmitted those documents.
Yes.
And at no point in time did you transmit any of these documents.
No.
Because if you had, it would have been that, I'll strike that. And is your testimony this evening that who was responsible for that?
Board clerk.
And was she the person, to your knowledge, who provided all of the other notifications
Yes.
of the time and place of board meetings and provided the access that was requested as well as copies of all of those documents?
Yes.
And I think we went over this, but one last question, was there ever a point in time where the board, through its minutes, because that's how a board speaks, through its minutes, requested that you handle any of those requests in the April the 12th, 2023 letter from Dr. Malone?
No.
Do you have anything additional to add to that bullet?
No.
And again, as written, as we started off, the way that it's written, failure to notify MDE of special call meeting on May 31st, 2023 pursuant to MDE directive, they knew.
They knew.
Yes. Okay, we will move to the last bullet now, which is the violation of the due process of an employee. And this started with a suspension letter, and that's on page 63 of our documents. What was the date of the letter?
March 21st, 2023.
Okay. And the letter is directed to an employee, and it states that she or the employee has violated standard 1 of the professional conduct of the Code of Professional Conduct and violation of standard 2.
Yes.
And what was your determination as far as the suspension?
The determination for the suspension came from a video that I saw of the employee, that the employee went to the.
I mean, when I'm asking that, I mean in terms of the days.
How many days was it?
Yes.
It was 3 days, Wednesday, March 22nd through Friday, March 24th.
And was there, was the suspension immediate?
Yes.
Okay. And, I'll direct your attention to page 56 and, Mississippi Code 37-9-59. If you look at the statute, the second sentence states, before being so dismissed or suspended, any licensed employee shall be notified of the charges against him, and he shall be advised that he is entitled to a public hearing upon said charges. Is that correct?
Yes.
However, if you jump down to about halfway between and starting with the line, the sentence that begins with "in," it says, in the event the continued presence of said employee on school premises poses a potential threat or danger to the health, safety, or general welfare of the students, or in the discretion of the superintendent may interfere with or cause a disruption of normal school operations, the superintendent may immediately release said employee of all duties pending a hearing if one is requested by the employee. Did this portion of the statute come into play in your decision to immediately suspend this particular employee?
Yes.
Is it your contention that the actions of this employee justified an immediate suspension?
Yes.
Did you believe at that time that the employee posed a danger to posed a potential threat or danger to other students?
Yes.
And did you also believe that the employee's continued presence on campus might disrupt normal school operations?
Yes.
Under such circumstances as those that are listed about halfway through the statute, those due process considerations that are given above at the very beginning, those are lifted. Is that correct?
Yes.
What specifically, and I want to get into what specifically you considered in determining that the employee was a danger. And I think that will require Mr. Waldington to give specifics about a video concerning the employee, and so it may not be appropriate for that to be an open session.
So at this time, Attorney Bailey, the board was only going to consider executive session for a personnel decision. The board is aware of the video that Mr. Waldington, Johnson Waldington speaks of. Attorney Palmer, if necessary, I would ask that he speaks broadly about the video and not necessarily specifics, if appropriate.
That would be appropriate, Mr. President.
And I would ask that, for the record, so that it is clear exactly what Mr. Waldington considered, that he be allowed to go into detail. Otherwise, broad statements may not accurately reflect exactly what occurred in those videos and what led him to the decision that he made.
Again, Attorney Bailey, it was your client's request to have a public hearing where if the matter was addressed in executive session, all of the details could be shared, but your concerns are duly noted.
So are you saying that he can go ahead and speak about the specifics of the
In broad
video?
terms, at all, only in broad terms.
Well, it is our request that he be able to speak about the specifics.
Mr. President, just for your information, there was a previous employee matter that was addressed by counsel opposite as a part of the presentation. I think it was a good job in avoiding naming that particular said employee, and I don't see any reason why that same approach would not be able to be taken with this particular matter.
Would that suffice, Attorney Bailey?
No, that's not at all what I'm requesting.
What is the will of the
I couldn't be more
board?
clear in saying that we want to be able to go into specific detail about those actions that the employee took and how, and the rationale that Mr. Waldington undertook, which is why he suspended the employee as he did.
Understood.
And that's what we want to be able to do. And we want to be able to do it on the record of that.
And again, for the record, your client asked for a public hearing, correct? Attorney Bailey?
That's correct. And I've already told Mr. Palmer, prior to this hearing tonight, Mr. Palmer was made aware in an email
Correct.
that there was specific, because these are he didn't come up with these himself. These are the areas that the board drafted in his termination. So he has to be able to respond to those in the manner that he deems appropriately. And so that's what he wants to do. And this is not a surprise. Mr. Palmer said, I will let you address it with the board and they will proceed in the manner, but he was well aware. If he wanted to, he could have talked to you about this in advance. So I don't understand what the problem is. We're asking for 5 minutes to go into executive session for him to be able to explain the details that are in that video.
Attorney Bailey, in that same communication to Attorney Palmer, which I was included on, you did set forth a manner in which we could move forward without the need for executive session, correct?
I said, yeah, that.
And Attorney Palmer just said
Is that all possible?
we can proceed based upon your recommendation as to how we proceed in regards to this matter. But again, I'll defer. What is the will of the board?
And I will affirm, Mr. President, that your representation is correct. The email that came from Attorney Bailey did give 1 or 2 approaches for the consideration of the board. One was to talk in general terms about whatever the issue was. And the second one was to go in executive session if that particular name would be mentioned. And as Council Officer just said, her presentation will be 2 things. One, the actions of that particular employee, and secondly, the rationale behind the decision of the superintendent to take whatever action he did take at the time. Neither one of those required the specific naming of that employee.
You have a question, to either allow non-business to our council. So with this particular state employee, how would the hearing, can you describe, this employee's due process? Can you describe what that hearing looks like?
Which employee are you referring to, Dr. Moore?
This employee that we're referring to, for the final bulletin.
So that particular employee, as the board should be aware, was an executive session. It did not go to a full hearing because of circumstances.
Question, had it gone to a hearing, what, can you provide a description of what that due process hearing would have looked like, maybe a brief description?
So a brief description of that due process was as follows. That particular employee received a suspension letter from the superintendent. That particular employee asked for a hearing. In fact, that same employee hired an attorney to represent her interests at that particular hearing. There was some correspondence to set the particular date in question for the board to consider that particular matter. The board decided to go in executive session due to the request of that particular employee, and because of certain matters that were brought to the attention of that employee as far as his or her rights, the board took it under advisement and they took the action that it took because of what the attorney had described in his presentation to the board. The answer to that question would be yes, they did have a hearing, albeit that it was not a full hearing on the merits. It was terminated in short, because of a motion that was made by that attorney in executive session.
And in the hearing, how would you have heard the intricacies of her side and, the district side, correct?
That is correct, and neither one of those particular individuals addressed in detail what occurred on the date in question. Again, once the attorney made his motion based upon a procedural matter, the board took that under advisement and made a decision based upon the procedural motion made by that attorney. So the board did not go into all the substantive facts of that particular hearing, if that's what your question is.
What is the will of the board in regards to Attorney Bailey's request?
I have no problem going into executive session. Hear the whole truth.
Is that a motion?
It is a motion.
Is there a second?
Second.
It's been moved and properly second to close this meeting for consideration of executive session. All in favor? Any opposed? Aye. Called for by name. Ms. Abraham, your vote. Coach Fant, your vote.
Nay, fact.
Dr. Moore, your vote. Nay. Dr. Moore, your vote. Nay, Rashawn Bailey. Nays have, motion dies for lack of a majority. You may proceed, Attorney Bailey.
Thank you. Mr. Waldington, were you provided videos of this particular employee?
Yes.
Describe in, without identifying the employee, what her actions were, or what the employee's actions were in the first video.
In the first video that you're speaking of, in the order that I sent them to you, the employee brought her children to the home.
Clarification. Let's not identify an employee by gender. Let's just say employee, if that's okay with you all. Thank you.
The employee brought their children to the home of a student that their children had gotten into a physical altercation with, basically a gang fight at one of our schools. And they brought those children to that home, and in the video, the children asked for one of the students that they had gotten into the physical altercation with, and asked them to come outside. And the person that was in the home asked, why? And the child stated, she knows what this is, she needs to come on outside. So that was the first video that was sent to you in that order. The second video had to do with the employee. The employee themselves walked up to the door of the home. All of this was video on a Ring video, and asked for the student that their child got into the physical altercation with, and then began to ask, where did the other children that got into the physical altercation with their child live? So with that being stated, through the video, with that being the case, it posed to me that that particular employee was, in a very heightened emotional state when it came down to that physical altercation between their child and their children and children at one of our schools. So that was the basis of the basis of what it was that I did with the suspension.
In the video, when the employee approached the home and was having a conversation, did she ask something to the effect, do you know where another student lives at?
Yes.
Was she provided an address or?
Attorney Bailey, let's not identify by gender, please.
I'll do my best.
Yes, ma'am, I understand, thank you.
Was the employee provided an address for a general vicinity as to where this other student actually lived?
A general vicinity, yes.
And in the first video, where the children were standing, as I recall, on the sidewalk, asking for the child to exit the home, where was the mother? Where was the employee?
I was not in the film. Was in the car.
Was the employee speaking from the car?
Yes.
What, if anything, concerned you about those actions that led you to immediately suspend that particular employee without allowing the hearing process to take place first?
That employee, based on the videos that I saw, was orchestrating a situation to where they were able to get their children to be put into a dangerous situation by bringing them to that home, by them going to the home. And with that being said, you know, if that was the state of mind of that employee, you know, in the community, it was incumbent upon me to make the best decision for the safety of the students in the Greenwood LaFleur Consolidated School District, you know, concerning that particular situation.
And is it your understanding, based on this particular statute, Mississippi Code 37-9-59, that you have the authority to do that?
Yes.
Was there also, in your letter to the employee, there was also a violation stated of trustworthiness?
Yes.
Can you elaborate on that? It's actually the last page, 63.
During the hearing, the disciplinary hearing for the students that were involved in the gang fight that happened at one of our schools, and gang meaning that it was more than two. It was 6 or 7 that was fighting. During the disciplinary hearing, it was asked by Dr. Bailey to this employee in so many matter of fact of words, employee, if I would say that there is a video that shows that you came to the home of one of the students that your child got into the physical altercation, you know, with, would that be accurate? Well, no, let me take that back. He stated that if I would say you went to one of the homes of the students that your child got into a physical altercation with, would that be accurate? She said no. He asked, okay, what if I would say that your children went to the home of one of the students that your child got into a physical altercation with. You know, and if I said that, would that be true? She said no. And he just nodded and said okay, and that was the end of that meeting. Well, the end of that questioning. And the video clearly shows that that was what had taken place.
So based on the actions as described, as you saw in those videos, and those videos, of course, were also provided to the board members along with the documentary evidence that we've been referencing tonight. It was your determination that this particular employee posed a danger and a potential disruption to the school environment that required her, in your discretion, because that's what the statute says, in your discretion, to be suspended immediately.
Yes.
And is it your position that those due process rights that are stated in the second sentence are not afforded employees when, in your discretion, there is a determination by you that their continued presence could be a danger or disruption?
Yes.
And of course, in any normal situation where there would not be an assessment by you that there was that type of danger, the employee would be entitled to due process prior to the implementation of suspension or termination.
Yes.
Do you have anything additional to add on that particular bullet?
No.
At this time, I would like to give you, Mr. Waldington, an opportunity to speak to the board and the public and list some of of your achievements, accomplishments during the short 11 months that you were superintendent, those things that you believe were an asset and improvement to this district.
I am, I am very, very, I'm a type of person as far as my job is concerned, especially that I'm having, a job that affects children's lives. I'm very serious and I'm very diligent in what it is that I do. For this, I'm not in this job just for the prestige of being a superintendent, because if you're an effective superintendent, this is an extremely hard and stressful job, extremely. But I feel that it is important that, from my standpoint, that I give back to the students, the type of students that I was when I was in school, that I went to school in rural Mississippi. And that's the reason why I work the way that I do. There were some words or phrases that were put in the termination letter, such as neglect of duty and incompetence, okay, is one of the words that were put in there. And that was something that really upset me to the point of that I would be labeled as incompetent and I was neglectful of duty. As a I was a superintendent for 11 years before I even came to the Greenwood DeFleur Consolidated School District. I had worked in school districts similar to this with similar issues, not as big, but similar issues. And I worked with the people that were there, that were in the community. Didn't bring an entire staff in. I worked with those people that were there, and we made sure that we gave those students the best education possible, and we made sure that we did things in the way that it should have been done. As superintendent, you know, I've been widely recognized as one of the most effective and accomplished superintendents in the state of Mississippi, not just in the Delta, but in the state of Mississippi. I've been recognized by the state board 3 times for academic growth in 3 different school districts, okay? I have been flown to Washington, D.C. to speak to a subcommittee on school improvement by MDE on the successes that we've had in school districts. I had to turn down invitations to speak in the state of Mississippi at different conferences about school improvement, about improving schools. So to put in a letter incompetence is, to me, and I don't know the law well enough, but to me, that is slanderous and that is libelous, to the point of you can't just put words on a person and you don't have anything to back that up. Neglect of duty for, I guess, for the Greenwood LeFlore Consolidated School District. In the 11 months that I was superintendent here, okay, you know, I set goals for the school district because the board didn't do it. I set goals for academics, for the crumbling infrastructure, for the very high chronic absenteeism that was in the district. I set goals and put in strategies for those things for us to be successful for the children in the school district. Raise the academic achievement on the pre-K state test by 17%, on the kindergarten state test by 18%. Establish the Excel Academy as a dropout prevention method that will help the students to receive their high school equivalency. We have 4 students to graduate from that. 4. Those were 4 students that had been expelled from this school district, and they came back. Now they have a high school equivalency. Now they can be productive in society. That's not something the board asked me to do. That's what it is that, as an effective superintendent, you do for your children if that's what your mindset is on. Establish a credit accrual program for students who have failed classes and to help them catch up with their peers. We have overage students in our classrooms. We have a 9-year-old at Threadgill Primary School, and that is a pre-K through 1st grade school. We know that that child needs to be able, there's going to be extra help that that child has to have to be successful. If not, you're going to end up with a child that's going to end up not being a credit to himself or society. So with that being stated, I established that and asked the board for approval, and they approved that. We had the first cohort of those students this year, this summer. I hate that I was not able to be here to assist, but there were over 80 students that was in that program, and that was just 6 through 12. You know, so you have the need for those things. Establish middle college program here in the school district to give the students an opportunity when they graduate from high school, they can get a high school diploma and an AA degree at the same time. Set those things up to be able to take them there, bring them back, have them a mentor, have all of the things that's needed for those students to be successful. Strengthen the partnership with the Delta Health Alliance to bring funds and jobs to the Greenwood LeFlore Consolidated School District and to assist our students in the pre-K-12 experience. People, secure $750,000 from the Mississippi Department of Education for roofing projects at M&L's High School, Bankston Elementary School, and Greenwood Middle School. implemented signing bonus for highly qualified teachers to come to our school district. One of the reasons that we have issues as far as growth with our students is that a lot of our teachers are teaching out of field, and we having to work with them to help build their capacity. So with that being said, implementing that signing bonus would be something that would help to get better teachers or highly qualified teachers in the classroom for our students. Solving the ongoing insect infestation at LeFlore County High School. I read about that in the newspaper before I got here. When I got here, there was an issue with, insects biting the students and the teachers at the schools. So that was a priority for me. And I found out what the issue was. All we had to do was pump some water away from under the school, dried up. We had no more problems out of that, and they haven't had a problem out of that since then. Achieved a satisfactory and above rating on my superintendent's evaluation that was completed in 2022. I got no negative marks on my overall. I got no conference about anything that was not being done in a correct way. I actually asked the board to email me anything that they would want to see to happen in the district. If my email had not been cut off immediately on June 7th, I would have been able to bring that to show you that I wanted that type of relationship with the board. I wanted them to be able to tell me what was it that you wanted from your superintendent that you had not received in that half a year, so that we can make plans to get those things done. Implemented an attendance procedure to assist with the chronic absenteeism issue in the school district. We received that from MDE. One of our schools had one of the highest chronic absenteeisms in the state of Mississippi, and we couldn't have that. How can you be successful if kids are not there? So we implemented that. And lastly, I would say this: the state test scores and the accountability rating for this school term. With the strategies that we put in place, with the way that our data was trending from our valid benchmark assessment, the Greenwood LeFlore Consolidated School District will not be a D school district. We will not have F schools in this school district based on what it is that we will receive. So with that being said, it's incumbent on me to say this. I'm asking, what more could I have done in 11 months? As far as what it was that was going on in the school district. Those 5 bullet points are unfounded, and I'm not going to say what the thought process of this particular situation is concerned, but I think that given an opportunity as the superintendent to continue to be the superintendent, this would be one of the best school districts in the state of Mississippi.
I don't have any more questions at this time.
I have a few, board. Mr. Waldington, good evening.
Yes, sir.
You doing well?
Yes, sir.
Good. Just a few questions regarding your testimony on the reasons why there was an initial determination to dismiss you by the board. Regarding your testimony, you indicated that Dr. Roshan Bailey on or about June 6, 2023 made a recommendation for termination based upon those 5 reasons that were listed in the June 7, 2023 letter that you received. Do you recall that being a recommendation by Dr. Bailey or a motion by Dr. Bailey?
The first one was a recommendation. The second one was a motion.
All right. When Dr. Bailey during the June 6, 2023 meeting listed those certain reasons to you that were at issue, did you get a chance to have a discussion with the board about your issues with the reasons that were presented to you?
No, not all of them.
So you did get a chance to address some of them.
Yes. And
Was there any reason why you did not get a chance to address all of the reasons?
Because there was so much back and forth in there with the board members, because it from my understanding and from what I was seeing, two board members had no idea that this was going to happen. So there was a lot of the conversation between board members. So with that being said, no.
You're saying no to what?
I didn't get a chance to address them all.
At any point in time during that meeting, did the board as a whole or any individual tell you that they didn't want to hear anything else you had to say before they made their motion?
No.
To terminate?
I'm so sorry. Go ahead. No.
I'm finishing my question.
No, sir.
Mr. Waldington, your attorney had you read a letter that is a part of the documentation that was provided to the board, specifically a certain June 7, 2023 letter that came from my office entitled Dismissal as Superintendent of Schools of GLCSD, June 7, 2023. You read the first part or page 1 of that particular letter, but there is a second page. Would you agree to that?
Yes.
All right. And in the questions that you were asked by your attorney, she asked if you were not granted a pre-termination hearing. Do you remember that question?
No.
All right.
Did she ask me?
Whether you had been given a pre-termination hearing.
Oh, yes.
And what was your answer to that question?
No.
So your response is that you did not receive a pre-termination hearing from this
Right.
board. Is that correct?
Right.
Now, correct me if I misread anything on the second page of this letter. The letter, again dated June 7, 2023, addressed to you from my office, says as follows. Under the above referenced statute, you are not entitled to a hearing on the charges made against you. However, if you desire to have a hearing, you must request a hearing by delivering a letter/correspondence to the attention of Dr. Roshan Bailey, GLCSD Board of Trustees President, within 5 calendar days from the date you receive this letter. If Dr. Bailey does not receive such a written request from you within 5 calendar days, your dismissal shall become final on the date you receive this letter. If you request a hearing under this procedure, a hearing will be set not sooner than 5 days, nor later than 30 days from the date of your request. You are entitled to legal representation at this hearing at your expense. If you timely request a hearing, your compensation shall continue up to and including the date that the initial hearing is set by the school board. In the event that you do not request a hearing, your compensation will cease the day your dismissal becomes effective. Is that an accurate recitement of what's in that letter?
Yes, sir.
And did you, in fact, request a hearing after the initial determination was made by this board on June 6, 2023?
Yes.
Mr. Waldington, did you also receive a certain letter from my office on June 13th, 2023, which was emailed directly to your attorney and was CC'd to Dr. Bailey, Dr. Moore, and yourself via email, which read in essence, secondly, because your client has requested a hearing, please be advised that he will receive compensation up to and including the initial hearing date set by the board for Friday, June 30th, 2023 at 5:00 p.m. Do you remember receiving that letter?
Yes.
Okay. And you stand here presently having a hearing on the determination of your dismissal today, is that correct?
Yes.
Have you received, I know we have just come from a holiday, but have you received payment through June 30th, 2023 from our school district?
Initially, no. I had to call the business office to get that done. But yes,
So you're saying you did eventually receive payment?
eventually, yes, yes.
Mr. Waldington, what does subpar mean to you?
Subpar means that that there was a goal that was not met.
Do you play golf?
I don't.
Looking at the documentation provided by your attorney on page 6, correction, 4 and 6. Would it be a true statement, even in light of your explanations regarding the increase in scores between the 2 years in question, which is 2022 and 2023, would it be fair to say that even during the 2023 year, that the overall average of the third grade reading initial summative assessment results for our district, Greenwood LaFleur Consolidated School District, is under 50%?
Yes.
And in fact, can you identify any other school district on the 2023 listing that falls under 50%?
On the list that we have now, or the list for the state of Mississippi?
The list that we have presently before us on page 6.
Stern Elementary School?
No, I'm talking about the district. My
Oh.
question's a district.
No.
All right. And just to be fair, there are other districts in the state of Mississippi, is that correct?
Yes.
And some of them, from your knowledge, if you know personally, fell below 50% regarding this particular assessment.
Yes.
Regarding the violation of Code of Ethics, which is one of the bullet points outlined on June 7, 2023 letter to you. And just to be clear for the record, Mr. Waldington, is it your understanding that the issue at hand was dealing with your denial as to being in an executive session meeting in February 2022 regarding a hearing for said employee in December 2022?
Could you repeat that, please?
In other words, there was a certain hearing December 2022, is that correct?
Yes.
And the allegation is that you did not speak truthfully regarding your appearance or participation in an executive meeting that was held in February 2022?
Yes.
Okay. At what point did you realize that you had misspoken regarding your participation in that particular meeting?
When it was brought to my attention that the board minutes stated that that was the case.
And do you know about when that was, or how long after the said hearing?
It was January the 4th.
The next month, is that be correct?
Yes.
Did you at any point in time contact anyone to correct the misspeaking by you regarding the hearing?
No.
Before you answered the question during the hearing, did you ask anyone to provide you with a copy of the executive board minutes to refresh your memory?
No.
Regarding failure to notify MDE of the special call meeting for May 31st, 2023, Mr. Walden, who scheduled that special meeting that was scheduled for May 31st, 2023?
I called Dr. Bailey and asked him for the special call meeting for that day.
So you would agree that you initiated that particular call?
Yes.
And what was Dr. Bailey's response, if you recall?
He was he said okay, and he would get and poll the board to see whether he would be able to have a quorum for that board meeting.
And in the meanwhile, did you ever inform any official of MDE of that special call meeting being scheduled on that day?
No.
Any reason why you did not inform MDE of that particular special call meeting?
It was the MDE was informed by the board clerk.
Can you explain?
The board clerk informed MDE that there would be a special call meeting before the work session. There was a work session that day as well.
How did the board clerk know about the prospective meeting being scheduled on that date?
I told the board clerk that we would have a special call meeting for that day.
All right. Mr. Walden, we don't have to say the board clerk's name, but how long had the board clerk been within this district?
I would say since July of 2022.
Okay.
2022, yes, ma'am. I'm sorry.
All right. Did the board clerk come before you came into the district or after you came into the district?
I don't remember. I don't remember whether it was before or after.
Okay. Do you recall whether you recommended the said board clerk for employment during the 2022-2023 school year?
Yes.
And that particular person answers directly to you, is that correct?
The board clerk?
Is that correct?
No. In her capacity as assistant to the superintendent, she does. As far as board clerk is concerned, you know, that is a separate job that she has, and you know, and as an employee, she does, yes.
Okay. But you do again acknowledge that you gave her the information about the special call meeting?
Yes, sir.
And do you also acknowledge that you're over day-to-day operations of the district, or at the time that you were superintendent here?
Yes, sir.
At what point in time did you realize that the special call meeting was not going to be able to go forward because of lack of quorum with the school board?
I'm not sure exactly what time it was.
But do you acknowledge at some point in time that you would have gotten knowledge that there was not enough board members in order to accommodate a special call meeting on May 31st of this year?
Yes.
At any point in time, did you consequently inform the board clerk that the board was not going to be able to meet for the special call meeting?
Yes.
And how did you go about doing that?
I told her office is right next to mine, and I called her. I wanted it was a verbal communication. I can't remember whether I called her in my office and said it or whether I paged her on the phone.
All right. And did you directly make any attempt to call MDE to let them know about the cancellation of the said meeting, special call meeting?
No.
Any particular reason why not?
Because I had not done that. That was not a part of my job responsibility, nor was it something that the board stated for me to do.
Okay. Was there a certain email sent by Dr. Malone to you and Dr. Bailey regarding not being informed about the special call meeting that was scheduled for May 31st, 2023?
It was yes, she sent an email. She stated that that the email stated that she was not informed, or they were not informed, that the special call meeting had been canceled.
All right. And since you mentioned Mr. Phillips, who is Mr. Phillips?
Mr. Phillips is a representative of MDE. I don't know exactly what his title is with them.
All right. And in fact, because there was no communication to MDE, they made a trip up here to Greenwood expecting to participate in the special call meeting. Is that correct?
Yes.
So you did get this particular email from Dr. Malone expressing concern about not being informed about the cancellation of the special call meeting. Is that correct?
Yes.
Regarding the violation of due process of employee, your attorney took great lengths to go through Mississippi statute 37-9-59. Do you remember going over that particular statute that is on page 56 of the information you provided to the district?
Yes, sir.
And regarding whatever actions this particular employee did, you found it necessary to suspend them based upon what your understanding was of what she had done. Is that correct? Or what the employee had done?
Yes.
Now, Counselor opposite asked you about this discretionary call that a superintendent can make if they feel that a certain employee poses a potential threat or danger to the health and safety and general welfare of students. Do you remember that question that your attorney asked you?
Yes, sir.
And let me direct your attention to page 63 of the information provided to the district by your attorney. Can you identify that particular document?
Yes, sir. This is the suspension letter for the employee.
Okay. And in this particular document, you provide notice to the said employee regarding the basis or the reasons why you decided to suspend this employee. Is that correct?
Yes.
Is there anywhere in that particular letter that you provide notice to that employee based upon your discretion that you felt that that employee was a threat or danger to the health, safety, or general welfare to the students?
No.
And is there any particular language in that particular letter that you drafted that further gives her notice that you are immediately releasing her from all duties pending a hearing?
No.
In fact, this particular letter only addresses the suspension as well as the reasons why you decided to suspend an employee.
Yes.
And you did acknowledge in your initial explanations to your attorney that this particular letter meant, in your words, an immediate suspension. Is that correct?
Yes.
Now, Mr. Waldington, isn't it a fact that this particular employee did provide you with notice that she wished to appeal your decision for suspension?
Yes.
Attorney Palmer, please be reminded that we're not identifying employees by gender, please. Thank you.
So noted. And isn't it true that the said employee ended up serving the suspension before she had an opportunity to present her case before the school board?
Yes.
And Mr. Waldington, would you agree that there is a difference between an immediate suspension and an immediate release of an employee of all duties pending a hearing?
No. Would I agree that there's a difference between the two? As a superintendent, to me, a suspension is a suspension, and so based on what it is that you just stated, no, is my answer. In my opinion, I say that.
So, Mr. Wallington, you would agree that if you, as a superintendent, immediately release an employee subject to a hearing, that that particular employee would not be immediately suspended? Would you agree with that?
Yes. Yes, I think I understand what you're saying. Yes.
And Mr. Wallington, isn't it true, well, back up. Was there an appeal of your suspension for this employee that was held in this school district?
Yes.
In fact, the hearing took place on April 19th, 2023. Is that correct?
I would have to look at the documentation, but I would say it did happen. Yes.
And do you recall during that particular hearing, the board going into executive session to deal with that particular matter regarding that employee?
Yes.
And was that employee represented by an attorney?
Yes.
Were you present during the initial presentation of that particular attorney regarding his concerns regarding due process?
Yes.
And do you also recall that he explained in that particular meeting his concerns that you as the superintendent had violated his client's rights of due process because you had indicated her need to serve the suspension immediately?
Would you please repeat?
All right. Do you recall the attorney for the employee explaining to the board of his concerns that you as the superintendent violated his client's due process rights by forcing her to serve her suspension despite the fact she had asked for a hearing?
Yes, I agreed that he stated that I had violated her due process rights based on that particular standard.
And in fact, after that particular presentation, do you remember the board dismissing some of the parties out of the room to discuss it in deliberation?
Yes.
And do you also recall that based upon the attorney's presentation to the board, that the board decided to overturn your decision to suspend the said employee, even though the employee had already suffered the suspension?
Yes, I was one of those.
Is that yes or no?
Yes. Yes, I was one of those that were asked to leave the executive session while the board deliberated. And when I came back, that's when the motion was made to dismiss, and the board, agreed to do that.
The board's indulgence, please. Mr. Walden, I've just handed you a document. Can you identify what that particular document is once you get a chance to review it? Without talking about who the specific employee is.
It states a transcript of proceedings. Parents noted herein as the date of April 19th, Greenwood LaFleur Consolidated School District, and the address reported by Todd J. Davis, and I guess his information at the bottom.
And can you review the other pages of that particular document behind the front page? You don't have to read it in detail, but I guess my question is that particular document the transcript of that particular hearing regarding the employee that we just discussed?
Yes, it looks that way.
And is it true and accurate to the best of your knowledge? Or is what was done in that particular proceeding?
I can't say because I hadn't had a chance to read it, but I hadn't had a chance to read it, I can't say.
Would you have any reason to deny that those are not accurate minutes from that particular meeting?
No reason to deny it.
All right. I ask that this particular document be published for the board's consideration. And also, I would just humbly ask the board that these documents be turned back in after you've had an opportunity to consider those, since it has sensitive information within them. Thank you. Board, I have no more further questions of Mr. Waddington at this time.
I do have a few quick follow-up questions for Mr. Waddington. I remember your testimony earlier regarding the evening of June the 6th. And you testified that while you had the opportunity to respond to some of these allegations, you did not have an opportunity to respond to them all.
Yes.
Is that correct?
Yes.
Were you told about this a potential dismissal, to have an opportunity to prepare in advance to respond to any allegations that evening?
No.
Did you have the opportunity to review any of these bases or any other documents and an opportunity to prepare for a response?
No.
Do you know the difference between a pre-termination hearing and a post-termination hearing?
I know the difference between pre and post, but not clearly.
Okay. Would your assumption be that pre-termination is before you're actually terminated?
Yes.
Is it your position that what we're having here tonight, is this a pre-termination hearing or a post-termination hearing?
Post-termination.
You have already been relieved of all of your duties effective June the 6th, were you not?
Yes.
And you were told to clear out your office the following day, July the 7th.
Yes.
And you had no further duties, you were relieved of all of your duties, had nothing else to do with the position of superintendent from that day.
Yes.
Now, you were asked by Mr. Palmer about subpar,
Yes.
and you were asked to compare the scores of Greenwood LaFleur Consolidated School District with others on that same page.
Yes.
Do you know whether those other districts were virtual or hybrid during COVID?
No, I don't know.
And so we don't know, you don't know how or whether that affected those scores at all.
No.
What, to your knowledge, was the general effect on test scores of school districts who were virtual?
Those test scores, the percentage of first-time passing went down from the previous years before the pandemic.
Going to just touching on the educator code of ethics, of what consequence was it whether the board was in executive session or not in March of 2022 when you were on Samantha Milton's speakerphone?
What consequence for me?
Yes.
No consequence.
Were you violating any rules?
No.
Okay. And so did you have any reason to misrepresent where you were, or the fact that, I guess not where you physically were, but that you were on a call in executive session?
No.
And is it your testimony that you were not aware that that was actually the case?
Yes.
And that you would not knowingly violate any ethical or the educator code of ethics regarding trustworthiness?
Absolutely not.
With respect to notifying MDE, as you stated earlier, MDE already knew about that meeting on May 31st. Is that correct?
Yes.
Okay. And then as far as the other meetings, after the March 12th letter from Dr. Malone, who was the person that was notifying MDE of the meetings?
The board clerk.
Was that person also the same person who was responsible of notifying MDE of any cancellations?
Yes.
And that was not your responsibility?
No.
And then finally, on the violation of the due process rights of that particular employee, the last bullet, your letter on page 63 notified the employee that she had a right to a hearing,
Yes.
and she exercised that option.
Yes.
And your letter also notified her of the basics.
Yes.
Did anyone ever tell you that you needed to include language from 37-959 in that letter?
No.
Did you work with anyone in addressing this situation concerning this particular employee?
No.
And so it's your position that in light of the statutory authority and discretion provided to you as superintendent, and in light of what you observed in those videos, and in light of the false testimony or the false information that was provided during the disciplinary hearing, that it was your determination that this particular employee was a danger and needed to be removed from the educational setting?
Yes.
And do you stand by that decision?
Yes.
And that's all that I have. Did you have anything additional you wanted to add prior to us concluding?
No. No, ma'am.
I did have one additional question. I'm sorry, I just thought of it. Going to your contract. On page 32, this is the contract extension that was dated December the 19th of 2022. That last paragraph, would you read that first sentence?
On page 32,
Yes.
termination shall be by written notice to the superintendent specifying reasons for termination and the nature of the evidence related to those charges, and provided to the superintendent not less than 30 days prior to the effective date of termination, unless termination occurs within the last 30 days of the term of the contract. In that event, notice. Okay, that's it.
In that sentence, as I read it, you should have been provided with written notice 30 days prior to the effective date of your termination. Is that correct?
Yes.
Is that what you received?
No.
The date of the notice, which was the letter from Attorney Palmer, I am so sorry, June the 7th, was the day after the board terminated you.
Yes.
Would you consider that a breach of your contract?
Yes.
That's all I have. In summary, I think we've gone through these ad nauseum. I think the board is well aware of our positions, and that we take the position that none of these bases are substantiated. There are, the results from the test scores speak for themselves. The testimony of Ms. Milton and Mr. Waldington speak that there was no intentional violation of any educator code of ethics, none whatsoever. Fiscal mismanagement, that was an inherited problem that was dealt with appropriately, and all the board members voted in favor of it, with the exception of Ms. Milton. Failure to notify MDE, that was certainly not his responsibility. That's a problem that the board had based on complaints to MDE, and the board clerk from day one has always been the person to notify MDE. Why are we putting this on the superintendent? It's not his responsibility, not by this board and not statutorily. And finally, he was well within the statute to suspend the particular employee based on her outrageous conduct in connection with that incident, and based on her failure to tell the truth to the board president in that particular hearing. So, based on information that we've presented tonight, we are requesting that Mr. Waldington be restored immediately to his position as superintendent, so that he can carry on the good work that he has already started. Thank you.
Just two matters. One, before we close out, I would like to admit this as district evidence number one, since it's the only document that I'm presenting as a part of this particular proceeding. Secondly, the board has heard the evidence. The board has one or two decisions to make. One, to uphold its initial determination to dismiss, which basically has been stayed because Mr. Waldington has asked for a hearing. And you've heard the presentation, so you all would have an opportunity to deliberate based on what you've heard to make a determination of whether or not to dismiss him or to reinstate him as the superintendent of the district based upon the presentation of evidence that you heard today. Thank you.
Attorney Bailey? Oh, you're fine. Yes, ma'am. Attorney Bailey, make sure the mic is on. I'm not sure we can hear you. Passes.
I would like to, for the record, state that we want to, on behalf of Mr. Waldington, admit all of the documents that were previously provided, pages 1 through 63, as well as the minutes of the trustees, Board of Trustees work session Wednesday, February 23rd, 2022, that was referenced in Ms. Milton's testimony, as well as the emails between Attorney Palmer, Dr. Bailey, and Mr. Waldington regarding transport of the documents to MDE. Thank you.
Thank you, Attorney Bailey. Chair will entertain a motion to close this session for consideration of executive session.
So moved.
Second.
It's been moved and probably second. All in favor? Any opposed? Ayes have it. Motion carries. No, you stay here. We're going to go somewhere else. You stay here. Attorney Palmer inform of the actions of the board, or what took place in executive session, if you will.
Board went to executive session.
Microphone. There you go.
All right, the board went into executive session, again, for personnel consideration of reconsideration or dismissal of superintendent. After due deliberation, the board vote was, the motion was made to reinstate the superintendent, and that particular motion was 2-2 for a vote.
Therefore, no action was taken. If there's any other, there are no other business, Chair will entertain a motion to adjourn. Second, it's been moved. I'm sorry.
I just would request a written decision pursuant to the contract within 10 days of consideration.
Attorney Palmer. It's been moved and properly second for adjournment. All in favor? Any opposed? Ayes have it. Motion carried. Have a good evening and be safe.